Welcome to another episode of Legal Expertise. I'm your host, Evantz Saint-Gerard. Got a special guest with me today, Vlad Portnoy. Vlad, before we go any further, where are you from?
Born in Russia, and I've been here in the U.S. since '92.
Where do you live now?
Well, I've lived in New York for the longest time. My office is in New York, and now I live in Jersey. And we have offices in New Jersey and New York. And in terms of my firm, that's permanently living in the middle of New York City.
All right. Now, let's talk about your firm. What is your specialty when it comes to legal expertise? Excuse me.
We do estate planning, wills and trusts, but there's 5 distinct subcategories of that. There's the pure estate planning for families and businesses. There is Medicaid planning for persons who require Medicaid. There's probates and administrations for estates of deceased. There's guardianships and a special needs planning. We also, as a subset of that, we do very brief, we don't do real estate fully, but we do help our clients with transferring co-ops and condos into trusts that we draft as an add-on. Sometimes they have their own lawyers, a real estate attorney, sometimes they don't. So that's fine. We don't go into commercial or anything uber complicated. That we gladly farm out. And for special needs planning, we work with people who what's called a public benefit preservation, which is where someone is on Medicaid already, and they either get an inheritance or they get a legacy, or they get settle a personal injury claim, and then they suddenly have this money that is not a lot to live on without Medicaid, but they at the same time they kind of require, so they don't want to lose it. It's still substantial amount of money, so we help them navigate that and preserve their benefits.
I find your field very interesting, especially on the real estate side. You mentioned 5 different subjects that we can tackle. Which one do you want to go with first?
We can just discuss in terms of real estate. What we've been doing is powers of attorney play a huge part in regular estate planning and in Medicaid planning, because someone may be involved in the real estate transaction and they may be elderly or physically not able to travel, so they can delegate it to their loved one, an adult child, a spouse, and they can, we've done a lot of that on that side. We've just drafted a lot of powers of attorney just to effectuate a real estate sale. There's also estate sales, which is where someone passed and you need our help with probate or administration. Probate is when you have a will, administration when you don't, but it's the same circuits court. We get the fiduciary for the estate appointed so they can sell real estate. And we also deal, as I mentioned before, we deal with people who are either planning to go on Medicaid or just inherited a house and they don't want to lose it, and we can structure it to transfer it into trusts or sell or things of that nature. So there's a lot of interplay between estate planning and real estate.
All right, so why don't we go into the power of attorney? I'm just looking at the questions that I have from some of our viewers that asked before. I'm looking at one of the questions. Do you have any stories of when a power of attorney is critical in real estate?
All the time. It's not even like one story I can go to. There's so many. The typical story, especially in New York. I mean, probably everywhere, but I'm very sensitive to it in New York City, where, let's say, a person is working all their life, and they are, they're married, they have a couple of kids, and they have a house, and they work for that house. That's their baby. That's their third baby, right? So and then as they get older, they still trying to hold on to this house, but they can't really keep up with the house, with cleaning the house and things like that. And then they really decline in health. And they're kind of holding on to it until the adult kids really interfere and go, look, we need to do something for you. We need to either downsize, we need to sell this house, we need to put you into a one-level apartment that you can, use in terms of using an elevator. You can't do split level anymore. Or the parent is diagnosed with onset of dementia, Alzheimer's, things of that nature, and now pretty soon it's inevitable that they won't even be able to to do anything about the property, and because they're still alive, it's not an inheritance, and then Medicaid might assert a lien on it. So we obviously, when someone already has a full blown dementia and they don't understand what they're signing, we cannot execute a power of attorney. So we always meet with the person when an adult child comes in and says, "Oh, I'm here on behalf of mom." Well, we need to see mom, and they're like, "Oh, don't worry about." No, I am worried about that, and we have some clients were very adamant that it's preposterous and they wouldn't proceed, which is fine with me. But most people understand, and we meet with mom. We play the 5 questions. We ask what date is it, who's the president, and see how lucid they are. And if they are, we can't stress this enough. We need the power of attorney immediately before mom forgets what her name is, and
Okay.
that happens all the time, every single day.
You're doing your due diligence not just for yourself, but also for the client and also for whatever the estate that they're playing, whatever they're maneuvering, what they're trying to do in the future. So these are questions that should
Absolutely.
be answered and taken into consideration. Now, after the person decides, okay, we need to get a power of attorney, we've met with you, mom is lucid, she understands what's going on, she doesn't want to have she doesn't she won't be able to make a decision probably in the future, but she wants to get ahead of this and basically get the power of attorney for whichever her siblings or kids that she feels comfortable with. Now, what's the next step after that? After the power of attorney is signed?
Well, then the power of attorney it doesn't strip the principal who gives the power of attorney of their natural adult rights. They can still act on it because a lot of people are dreading this, giving the power of attorney because they believe they're just giving up their possessions. Obviously, if you can't give it to someone you don't trust because it must be given voluntarily, willingly, and knowingly.
Say that, say that one more time. I want the audience to hear that last sentence you just said. You don't give the power of attorney to people you don't trust. Say that one more time, please.
You don't give the power of attorney to people you don't trust just because they're there or they're whatever. And especially you don't give the power of attorney to your brand new home attendant that just happened to be feeding you, because that's called elder abuse. And by the time the adult children who may reside out of state and for work catch up, suddenly, a 98-year-old man is married to his 26-year-old sitter, and there's a contest. So you have to know who to give it to. Unfortunately, there's a lot of undue influence where someone might be slowly kind of dripping the knowledge, the false knowledge into someone's head. But all that aside, you absolutely need to trust whoever you're giving the power of attorney to, because the power of attorney is not an inheritance. It is a way for someone else to supplement your natural right that no one's taking away from you to manage your assets, especially real estate, because that is the centerpiece of anything. It's the easiest to get to, and it's the most valuable. And you absolutely need to make sure, because look, New York has a statutory power of attorney. Other states don't. No one has that. It's like I can use one state's power of attorney and just say, now it's subject to laws of Florida because it doesn't matter. It's like I nominate this person to do this. Fine. But New York has so much fraud, or people plead ignorance, saying, grandma gives her grandson a power of attorney. He immediately transfers $100,000 and goes partying in Mexico. And then Dog the Bounty Hunter goes after him, and he says, I did not know I couldn't do this. I thought she was making a gift. It is not a gift. The person must be mature and understand and appreciate what it means. And so you have to have the person who is mature, who understands, who has a sound judgment of an average person, whatever that means, and that they will act with your money for your benefit as long as you're alive, because the power of attorney dies with the person. And so, side note, a lot of people come in and say, grandma died 2 weeks ago, I have a power of attorney. You can't. That's it. And then
You have
like,
to have
well,
paperwork.
it's kind of too late. Yeah, I have the paperwork. What do I do with it? Well, nothing anymore. That form has expired with grandma. And that's also very common. Um, it's a very common way of people treating, because they don't know the difference. They're like, well, we didn't get to the will and part, but what can I do with power of attorney? Well, nothing.
All right, so let me see if I got this correctly. So basically, if I have a power of attorney for, let's say, my mom or my new girlfriend who's 80 years old,
Nice.
she happens to pass away. Once she passes away, that power of attorney is no longer is void. As long it's only as good as till the person's alive. Is that, am I understanding that
Yes.
correctly? Okay.
Yes.
So basically, if I have a power of attorney,
And
as long as
yeah,
the person's
it's
elusive,
only as it expires.
as long as that person's
Well,
elusive and I have the
the
power of
thing is that
attorney.
the person must sign the power of attorney when they're lucid.
Okay.
But it's supposed to be used when they're actually not lucid anymore. So if they're still alive, but they're stricken with full-blown dementia, this is the time for their trusted agent to be acting on their behalf. Like if you did this for your mom, that would be the ideal situation.
At that point, while the person's still
Or
alive,
80-year-old girlfriend.
or 90, well, I'm not discriminating.
I
But
mean,
let's just say,
let me know if she has a younger sister.
you mean older sister. But let's just say that this person,
Oh,
as you're having the conversation, as you're having this conversation with your family members, you might want to start looking into the trust and the will. Obviously, you want to go the trust route because you want, as a person's alive, they are elusive and they know exactly what their plans are. Should they do cross over to the other side, you follow whatever the instructions are, basically. So that's why you pick the right person to be your power of attorney, and you make those decisions for yourself, for your family members. But you wanted to say something else.
no. I mean, we can talk for hours about this, but it's important with the power of attorney to be cognizant that this has to be done when nothing is wrong. Because sometimes when things go wrong, let's say there's feuding siblings that never got along, and one of them just starts transferring assets somehow, and then the other one runs in and says, let's do a power of attorney. Okay, well, what's this going to do? Because half the stuff is already gone. And then if mom dies now, they will want their half of what's left. And whatever they transferred without even power of attorney or with a fraudulently procured power of attorney, they'll say mom wanted to give him a gift. And then you have to prove that that's not the case.
So regardless of whatever you're choosing to do with your family members, you have to have the conversation with your family, whether you get along or don't get along. It has to be open dialogue, have the conversation, and then seek professional help, which would be an attorney that specializes in this sort of thing, so you can iron out what's actually going to happen if in case that person does pass away. It's a clear guideline of what their final wishes were. So I would say basically have that conversation, find an attorney
Right.
like Vlad, and have those conversations, and then document everything that you need, so everybody can respect what your final wishes are. All right, so we're talking about trust now, which comes up a lot, especially in my field when I'm selling homes. Someone passes away, unfortunately, and the person who is their guardian, or in this case, basically the person who's in charge of the sale of the home, if one of the first things we ask is basically, is there trust? Was there will? What's the situation? For this situation, I'm just going to throw out a hypothetical. Sam calls me. His parents passed away. They need to sell the house. Sam is no longer here in New York. He's in another state, so he can't handle this property at this point. He needs to do what he has to do, sell the property. What's his legal recourse? What's he supposed to do? What's his first step?
Well, look, him not being physically here does not preclude him from acting on behalf of his parents' estate. So he needs to get appointed. So the appointed is a fiduciary of the estate. It's an executor when it comes to probate, when there's a will, so he's nominated, and it's an administrator when there's no will and goes by operation of law. And once he gets, and the claim has to be filed at the county of residence of his parents in the surrogate's court. So there's one per county. You can't forum shop. You can't go, parents passed away in Queens, but I think Erie County, upstate New York, has less of a backlog. I'm going to go there. That's not how it works. So it has to be specifically in the county, and all the interested parties must be given notice. Like if he has siblings, or if one of the parents is surviving, and and the property did not go by operation of law automatically if they were joint tenants, for example. And then once he gets appointed, he can manage this property. So as long as he's a resident of a state, he could be even working abroad technically, but he's a resident. He has a mailbox here. He pays taxes here in New York, in Jersey, California, Florida, whatever. He's appointed. And then It's his job to what's called marshal the assets, collect all the information, collect all the cash, figure out what's where. Then stage two is pay the creditors. So if his parents had mortgage on the property, he would need to address that, preferably with the other assets without selling the house. Or if he wants to sell the house and satisfy the mortgage, that's also great. And it's we kind of want to see, a lot of people want to keep the property or transfer the property or sell it at a different time or do whatever other things. Nothing's wrong with selling it, because a lot of times, parents lived in an area where the kids just don't want to live, and they will sell it, and it's called an estate sale. And so what? So he would have to. His job as a fiduciary would be to just effectuate the transaction. In that sense, he's not going to be brokering his own property. He would need your help, clearly. He would need to go to professionals. He would absolutely need a real estate attorney. He would need a real estate broker. And, you're one of the finest ones. We've known each other for many, many years.
Thank
Clearly,
you.
that's why I'm here.
The check's in the mail.
Yeah. But the reality is, you know your stuff, and the estate sale would be not everybody can handle it, because there's a lot of brokers who can do regular sale because that's what they do, but the estate sale has other bells and whistles that you kind of need to be familiar with. So you have to have been around long enough to appreciate the circumstances. But and a lot of people do it on their own. They try to sell the property, they ultimately fail, and it commits what's called a waste to the estate, where the property is undersold, or there's some kind of a damage, or they let a renter in who trashes the property. It devalues it or lowers the value, and now as a fiduciary, they're responsible to their siblings for decreasing their share of the property. So obviously, again, you need a lucid person who is with a solid, normal, average business judgment, who can figure this out. And
I'm glad you mentioned that, because we do run across that quite often. As we're speaking right now, we have a couple of situations similar to what we just discussed that are happening as we speak. And one family, I can't say too much because it's still ongoing. The family basically has several siblings, so obviously everybody has to be on the same page. Our job as realtors is to speak to everybody involved in the situation, make sure all the siblings, whatever information that we get, we're putting the house on the market. Okay, great. Everybody has to be on board. It can't be, all right, 5 are on board and 1 is not. Everybody has to be on board. And then we go through the finances. Basically, this is what we need to know, everything that basically is owed on the property, which we find out. And pretty much if there's any other debts on the property or regarding the family, like you said, we try and get everything paid off, either through the mortgage needs to be paid off if there is a mortgage, or if there's any other debts basically that need to be paid off. We get all that information. Obviously, we have the attorneys involved, and then we put everything together. And like I said, the main important thing is to have the conversation. Everybody has to be involved in the conversation. Everything out in the open on the table. And once we know all the information, we can proceed properly.
Yes. And then you obviously you mentioned it before, you need to do your due diligence. And you need to educate all of the clients, even the ones that are not directly involved. If there's a cousin, or again, you can have a power of attorney for parents who are selling the house and they're alive, and the kids, but they're kind of meddling. They're kind of coming in, and the kids are using power of attorney to help them, and they're just coming in and going, what's going on in there? Like, okay, you should be at those meetings, even if you're not going to be at the closing because you have trouble walking. Like, you need to do this, and it's very important for everybody to understand that.
I'm glad you said that. We do have siblings, kids, whoever the power of attorney is. We do this on a regular basis. They're not familiar with this, and obviously, as a child, you want to protect your parent at all costs. So we try to include them in the conversation with their parent. Obviously, the parent basically gives us the green light. They are our client, and whatever they say they want to do, that's what we do. We include the power of attorney, whoever's in the conversation, based on what our client has told us. Do you want this person in on this conversation or not, or do you want us to relay it to them after the fact? Whatever you decide to do, that's what we're doing.
Yep, absolutely.
All right, so walk me through we got the trust. We have we're not doing the probate right now. The family's putting the property onto the market. We sold it. We're in the contract. We're selling it right now. Walking through basically the closing.
Well, the if we you said we're not selling, right?
No, we are selling. We are selling the
We are.
property.
I mean, the closing is basically it depends. That is not the complicated part because if we're selling something out of the trust, you just need the only difference is you need an owner of the property to be present. So if you have regular mom and dad, then they're going to be sellers at the closing, and someone else can be a buyer. But if the house is now in the trust, then you
Yes,
need
it's
the
in the
trustees
trust
of the
now.
trust, which is usually the adult children, and they don't own it because they're like directors of a corporation. They are, but they're representatives of this legal entity. And just for the record, this is not really, this is tangentially related, but just for the listeners, when people say, do I need a will or a trust? The will is owns everything you own at death in your name under your social security number. A trust owns what you've put in it physically. It's called funding the trust. So it's not either or, it's usually both. Because you can have a house in a trust and a bank account in your name, you will need both. So here we're talking about specifically trust that's been funded with a real estate that we're now selling.
Okay, so now we're at the closing table. The funds have been transferred. The funds are transferred over to the trustees, and the trustees pay off whatever they have with the bank, let's say Medicaid bank, whatever other things that are due. The attorney basically helps them put everything together, and they pay off what they have to pay off. And then whatever else money's left over, the trustees do with whatever the person who passed away, whatever their final wishes were. They take care of that. Is there anything else that the viewers need to know regarding this process?
Well, then what happens is because the trust is separate from the will from probate, the trust is what's called a non-probate vehicle. It holds non-probate assets, so we don't need to go through court. We don't need court's blessing, and it's done immediately. So now the funds are not going to to the adult kids as beneficiaries yet. They go to the adult kids, and I mean, again, it could be anyone, but they go into trustees as the directors who accept the property, and now they have to look to the trust in to properly administer the shares. And so when everything, let's say, I don't know, you have $1 million property, there's a $300,000 mortgage minus fees, let's say, I don't know, $500,000, $600,000 in the trust, and it says to my adult children equal shares. Okay, well, do you have two or three or five? What's the equal share? You take that as 100%, divide it by number of kids, there you go. Or you go, well, off the top, I want 20% to go to the Red Cross. A lot of people are charitable. They're charity minded. We have a lot of clients who are affluent or in a very specific mindset, like who have all their life been involved with nonprofits or in academia. They want to give back to the community, to their institutions, and it's very important. So the kids might not like it, but it is what it is. Or sometimes it's actually,
it's the final wishes. You have to respect the final wishes, whatever they want.
yeah, but sometimes it's actually done on purpose, and the kids actually love it because sometimes it's done for tax purposes to offset liabilities because you get the charitable exemption, and it's fabulous. So it's not always a bad thing, but you have to. But the trustees with the money have an obligation to follow the rules and then administer the beneficiaries whatever their share is.
We gave them a lot of information to digest. So if they want more details, figure out basically if they should go the route of trust or estate planning or whatever, how can they reach you?
We are easily reachable. I mean, we're on the internet. We have our main number that you can always reach us at is 212-6371, 212-920-6371. And we will be able to schedule an appointment, be it for New York or New Jersey office or Zoom. But we have licenses for New York and New Jersey, and that's our wingspan. Usually we're in Bergen County, like North Jersey, and we are in New York City and the boroughs of New York City. So anywhere between Suffolk to maybe Westchester, Rockland. The 5 boroughs of New York City is our preferred.
All right. Well, you heard it from the man himself, the man, the myth, the legend. If you have any questions about real estate regarding selling, relocating, probate situations, anything regarding real estate, feel free to reach out to me. I'm Evan St. Gerard. My number is 917-975-5985. I'm a New Yorker. I'm sorry I talked too fast. I'll slow it down. 917-975-5985. You can also reach us on our website, which is mynyhomesales.com. TikTok, Facebook, Instagram, pretty much you name it, we're probably on it. Remember to like, share, and subscribe. If you have any questions, feel free to leave the comments down below or just DM us, and we'd love to answer questions. Talk to you soon.